Module 4, Legal and Ethical Considerations. Welcome to Module 4 of our Mastering Entrepreneurship course. In this module, we will address the critical legal and ethical aspects of entrepreneurship. Navigating the legal landscape and conducting business with integrity are fundamental to your venture's long-term success. Let's explore this in detail. 4.1 Legal Structures for Startups. This section will cover the various legal structures available to entrepreneurs, including sole proprietorships, partnerships, limited liability companies, LLCs, and corporations. You'll learn the advantages and disadvantages of each, helping you choose the right legal structure for your business. Choosing the right legal structure for your startup is a critical decision, as it can impact your liability, taxation, and operational flexibility. Here are some common legal structures for startups. 1. Sole proprietorship. A sole proprietorship is the simplest structure and involves a single individual owning and operating the business. The owner has full control but is personally liable for the business's debts and obligations. It's ideal for small, low-risk ventures. 2. Partnership. A partnership is similar to a sole proprietorship but involves two or more individuals sharing ownership, responsibilities, and profits. Partners have personal liability, and there are two main types: general partnerships, shared responsibilities and liabilities, and limited partnerships, with one or more limited partners who have reduced liability. 3. Limited liability company, LLC. An LLC combines the limited liability of a corporation with the simplicity and flexibility of a partnership. Owners, members, are not personally liable for business debts, and it offers various tax options. It's a popular choice for startups. 4. C Corporation. A C corporation is a separate legal entity from its owners, providing liability protection for shareholders. It allows for an unlimited number of shareholders and is suitable for businesses seeking to raise significant capital, go public, or have complex ownership structures. 5. S corporation. An S corporation is a tax designation rather than a legal structure. It provides liability protection like a C corporation but has pass-through taxation, which means business profits and losses are reported on individual shareholders' tax returns. S-corp have restrictions on the number and type of shareholders. 6. B corporation. Benefit corporation. A B corporation is a type of legal structure that emphasizes social and environmental goals alongside financial returns. It's a good choice for companies committed to achieving positive impacts beyond profits. 7. Cooperative. Co-op. A cooperative is owned and operated by its members, who share in the decision-making and profits. There are various types of co-ops, such as worker cooperatives and consumer cooperatives, each with its unique structure. 8. Non-profit organization. Non-profits are structured for charitable, educational, or social purposes. They have special tax benefits but must reinvest revenue back into the organization's mission. 9. Professional corporation, PC. PC structures are for licensed professionals, such as doctors, lawyers, and accountants. They provide liability protection while allowing professionals to work together. Choosing the right legal structure for your startup depends on factors like your business goals, the number of owners, the level of liability protection needed, and tax considerations. It's essential to consult with legal and financial professionals to make an informed decision that aligns with your specific business needs and long-term objectives. 4.2 Intellectual property and patent basics. Intellectual property, IP, is a valuable asset for many businesses. We'll explore the different types of IP, such as trademarks, copyrights, patents, and trade secrets. You'll learn how to protect your intellectual property and respect the IP rights of others. Intellectual property, IP, refers to creations of the mind, such as inventions, artistic works, and brand identifiers, which can be legally protected. Intellectual property rights grant the creator or owner exclusive rights to use, reproduce, or license their creations. One of the most common forms of IP protection is through patents. Here are the basics of intellectual property and patents. Intellectual property, IP. 1. Types of intellectual property. Copyright protects original literary, artistic, and musical works. Trademarks safeguards symbols, names, and slogans used to identify goods and services. Patents grant exclusive rights to inventors for their inventions. Trade secrets protect confidential business information. Industrial designs shield the visual design of industrial products. Plant variety protection covers new varieties of plants. 2. Copyright. Copyright protects original works of authorship, giving creators exclusive rights to reproduce, distribute, and adapt their work. It covers literary, artistic, and musical creations. Copyright is granted automatically upon the creation of the work. 3. Trademarks. Trademarks protect brands and distinguishing symbols, names, and slogans. Registering a trademark with the appropriate government agency, example the U.S. Patent and Trademark Office, provides exclusive rights to use it. Patents. 1. What is a patent? A patent is a legal document that grants inventors exclusive rights to their inventions for a limited time, usually 20 years from the date of filing. Patents protect novel and non-obvious inventions, providing a legal monopoly to the inventor to make, use, and sell the invention. 2 types of patents. Utility patents cover processes, machines, manufactured items, and compositions of matter, example new technologies, machines, chemicals. Design patents protect the ornamental design or appearance of an article of manufacture, example unique product designs. 3 patent requirements. To obtain a patent, an invention must be novel, new, non-obvious, and useful. It must be adequately described in the patent application. 4 patent application process. Inventors must file a patent application with the relevant patent office. The application includes a detailed description of the invention and often requires legal and technical expertise. Once granted, the patent holder has exclusive rights to the invention for the patent's duration. 5. Enforcement. Patent holders have the legal right to enforce their patent rights and sue anyone who infringes on their invention. Enforcement can involve litigation to protect their exclusive rights. Intellectual property, including patents, is crucial for protecting and incentivizing innovation, creativity, and business growth. Entrepreneurs and inventors should consider these forms of IP protection to secure their ideas and inventions while fostering a competitive and innovative environment. Consulting with intellectual property attorneys is recommended when seeking to protect your intellectual property. 4.3 Ethical challenges in entrepreneurship. Ethics is the foundation of a reputable business. In this section, we'll discuss common ethical challenges faced by entrepreneurs, including transparency, honesty, and social responsibility. You'll learn how to make ethical decisions and build trust with your stakeholders. Ethical challenges in entrepreneurship refer to the moral dilemmas and issues that entrepreneurs may face while starting, running, or growing a business. These challenges often involve balancing the pursuit of profit and success with ethical principles and social responsibility. Here are some common ethical challenges in entrepreneurship. 1. Honesty and transparency. Entrepreneurs may be tempted to withhold information or present a misleading picture of their products, services, or financial status. Maintaining honesty and transparency is essential for building trust with customers, investors, and stakeholders. 2. Fairness and equity. Entrepreneurs often deal with issues related to fairness, both in their internal operations and external interactions. Fairness extends to employees, customers, suppliers, and partners, and entrepreneurs must ensure that all parties are treated equitably. 3. Conflict of interest. Balancing personal interests with the best interests of the business can be challenging. Entrepreneurs must avoid conflicts of interest and make decisions that prioritize the well-being of the business and its stakeholders. 4. Intellectual property. Respecting intellectual property rights is crucial. Entrepreneurs should refrain from infringing on the intellectual property of others and take steps to protect their own intellectual property. Ethical handling of intellectual property fosters innovation and trust in the business community. 5. Data privacy and security. Entrepreneurs often handle sensitive customer data. Maintaining the ethical responsibility to protect this data, comply with privacy regulations, and prevent data breaches is vital. 6. Environmental responsibility. Sustainable and ethical business practices are increasingly important. Entrepreneurs should consider the environmental impact of their operations, from sourcing materials to waste disposal. Ethical choices promote environmental sustainability. 7. Compliance with laws and regulations. Adhering to applicable laws and regulations is a fundamental ethical obligation. This includes employment laws, tax regulations, industry standards, and more. 8. Consumer protection. Entrepreneurs have a responsibility to protect consumers from deceptive or unfair business practices. Ethical entrepreneurs provide clear terms, honest pricing, and products or services that meet quality and safety standards. 9. Social responsibility. Entrepreneurs may face ethical challenges related to their business's impact on society. Being socially responsible includes addressing issues like labor practices, community engagement, and philanthropy. 10. Long-term impact. Ethical entrepreneurship goes beyond immediate profit. Entrepreneurs should consider the long-term impact of their decisions on their business, reputation, and society as a whole. Ethical business practices can lead to sustainable success. Addressing ethical challenges in entrepreneurship requires establishing a strong ethical framework, ethical leadership, and clear guidelines for decision-making. It's also essential to seek ethical guidance, education, and training to ensure that ethical principles are integrated into the business's culture and operations. By prioritizing ethics, entrepreneurs can build trust, reputation, and sustainable success in their ventures. 4.4 Contracts and agreements. Contracts are the backbone of business relationships. This section covers the essentials of contract law, including contract elements, types of contracts, and the importance of well-drafted agreements. You'll also explore negotiation techniques for creating win-win agreements. Contracts and agreements are legal documents used in business to establish and define the terms, rights, and obligations of parties involved in a transaction or relationship. They serve as written evidence of the agreements made and provide a framework for resolving disputes. Here's an explanation of contracts and agreements. Contracts. A contract is a legally binding agreement between two or more parties that outlines their rights, responsibilities, and obligations. 4. A contract to be valid, it must generally include the following elements. 1. Offer. One party makes an offer to do something or provide a product or service. 2. Acceptance. The other party accepts the offer, indicating agreement with its terms. 3. Consideration. Both parties exchange something of value, money, goods, services, etc., as part of the agreement. 4. Legal capacity. The parties entering into the contract must have the legal capacity to do so. This means they must be of sound mind and of legal age. 5. Legal purpose. The contract's purpose must be legal. Contracts for illegal activities are not enforceable. 6. Mutual consent. Both parties must freely and willingly agree to the contract's terms. Contracts can take various forms, including written contracts, verbal contracts, and implied contracts, where the terms are not explicitly stated but are inferred based on the parties' actions. However, written contracts are the most common and provide the clearest documentation of the agreement. They often include specific terms and conditions, timeframes, responsibilities, and provisions for dispute resolution. Agreements. Agreements are broader in scope and can encompass various types of arrangements. They may or may not be legally binding, depending on the intent of the parties involved. Some common types of agreements include 1. Non-disclosure agreement. NDA. An NDA is a legal agreement where one party agrees not to disclose certain confidential information to others. NDAs are often used to protect trade secrets, business plans, or proprietary information. 2. Memorandum of Understanding. MOU. And MOU is a formal agreement between two or more parties outlining their intention to work together on a particular project or goal. It may not be legally binding, but it can serve as a framework for future contracts. 3. Letter of Intent. LOI. And LOI is a document that outlines the terms and conditions of a potential transaction or business deal. It expresses a party's intention to proceed with negotiations. 4. Partnership Agreement. A partnership agreement outlines the terms of a partnership, including the rights, responsibilities, and financial arrangements of the partners. 5. Service Level Agreement. SLA. And SLA is a contract that defines the level of service one party will provide to another. It often includes performance expectations, metrics, and remedies for noncompliance. 6. Employment Agreement. An employment agreement outlines the terms and conditions of employment for a specific position. It can include details about compensation, job responsibilities, and non-compete clauses. 7. Sales Agreement. A sales agreement specifies the terms of a sale, including the price, delivery, and terms of payment. Agreements can be legally binding, but they may also serve as preliminary documents that lead to more detailed contracts. The nature and enforceability of an agreement depend on the language and intent expressed within the document. When in doubt, consulting with legal professionals is advisable to ensure that contracts and agreements meet the necessary legal standards and protect the interests of all parties involved. This concludes Module 4.